I guess he claims to be from Georgia. But I don't think really in this day and time what state they originate from is all that relevant. Anyway, I'll bring this to a close now so there'll be time for questions. But if anybody want to raise questions about the current issues or the ideology of the various justices, I'm sure any of the panel, as well as Dr. Barchet, even can address that.
Thank you, Ron. Appreciate that. Even Dr. Barchet might know something on occasion.
Oh, I know you know something.
Angela?
Prove it all.
I'm Angela. How do you do? I have the privilege of just talking about some recent cases, and though I admit up front I'm a Steelers fan from Pittsburgh, as is, thank you. Where's President Dukes? She's also from Pittsburgh. And they didn't do, I don't know about that kicker that we have. I'm a little concerned this year, but we do have a lot of Super Bowl rings. Anyway, I'm sure on your mind more is the Redskins, and perhaps about to go to the Supreme Court is a case with the Redskins. Anybody familiar with that? Yeah. What's about to happen?
They want to get rid of their name.
Right. So one of the things that I want to try to bring home this morning in just 2 or 3 cases is a wide range of things that the Supreme Court hears and perhaps decides that affects, directly or indirectly our lives. So with regard to the Redskins, the U.S. Supreme Court has been asked to rule on whether the nickname of the Washington Redskins is too offensive. And it's really a trademark issue. The fight against the trademark began in 1992 when 7 American Indian activists filed suit challenging it, saying it was too offensive to merit trademark protection by the U.S. court or by the United States. So the Supreme Court will be left to decide whether it is too offensive to merit trademark protection. And this case has been going on since, as I said, 1992, and it's gone through various courts, and sometimes the plaintiffs win, and sometimes they're reversed, and so we might get a final decision on it. What do you think? Too offensive? No. What could they be called if not the Redskins? The Warriors, yeah. Why might that be different, the Chiefs and the Braves, the Sentinels, from Redskins? So that's a very important point, too, about the emblems as well as the name. However we stand on it, the Supreme Court will get to decide, and perhaps that's why the makeup of the Supreme Court is so important. But that's right, they feel, some Native Americans feel, at least the plaintiffs who brought the case, feel that it's a derogatory term, whereas the Chiefs or the Braves might not be. Yeah. Yeah. Okay, so that's one case. I also wanted to look at a student case, and this case, these are all recent cases. This was decided June 25th, 2009, so a very recent case, and it has to do with search and seizure of students. In this case, it was a 13-year-old. After escorting a 13-year-old Savannah Redding from her middle school classroom to his office, Assistant Principal Wilson showed her a day planner containing knives and other contraband. She admitted owning the planner, but she said that she'd lent it to her friend Marissa and that the contraband was not hers. He then produced 4 prescription strength and 1 over-the-counter pain relief pills, all of which are banned under school rules without advance permission. She denied knowledge of them as well, but Wilson said that he had a report that she was giving pills to fellow students. She denied it and agreed to let him search her belongings. He and Helen Romero, an administrative assistant, searched Savannah's backpack, finding nothing. Wilson then had Romano take Savannah to the school nurse's office to search her clothes for pills. After Romano and the nurse, Peggy Shaw-Waller, had Savannah remove her outer clothing, they told her to pull her bra out and shake it, and pull out the elastic on her underpants. This is just a case, on her underpants, thus exposing her bare skin. I've cleaned that up a little. No pills were found. Savannah's mother filed suit against petitioner at the school district, alleging that the strip search violated Savannah's Fourth Amendment rights. Fourth Amendment rights. So the Supreme Court had to decide, did it? What do you need for a search? Well, I can say that here's what they decided. For school searches, the public interest is best served by a Fourth Amendment standard of reasonableness that stops short of probable cause. And so they're saying that you don't need, that the standard is a little bit different in school searches.
Much more egregious, correct?
Under the resulting reasonable suspicion standard, funny you should ask, a school search will be permissible when the measures adopted are reasonably related to the objectives of the search and not excessively intrusive in light of the age and sex of the student and the nature of the infraction. So this was all taken in context. I think that's what you're trying to point out. It's not so much that students can't be searched. It's the context of what's the infraction. I mean, here literally they were looking for non-prescription medicines. What's the infraction? What's the age of the student? Things of that nature. Okay, and I think I have time for one more. On a slightly different note, again, just trying to demonstrate the broadness of the Supreme Court's overview powers. Well, one of the ways that we as a country acquired Hawaii was in 1893, the Hawaiian monarchy was overthrown by private U.S. citizens with the help from the U.S. government. And the Queen protested the forceful taking of Hawaiian land, declaring that she yielded the land only until the U.S. government recognized the overflow as unlawful and reinstated the Hawaiian monarchy. That was 1893, and of course we know that that hasn't occurred. 5 years later, President McKinley signed the Newlands Resolution, pursuant to which the United States annexed Hawaii, that's one, and the Hawaiian government ceded 1.8 million acres of land to the federal government. So we now have an ongoing case where some of this land is trying to be developed. And the question is, in this case, whether who has rights to develop the land, whether it's the Hawaiian government, whether there's still some monarchy rights to it, or whether it's, it's part and parcel of the United States. All right, thank you.
Thank you, Dr. Rabatin. That's very interesting. Just one observation. Generally, there have been a series of cases concerning high school student rights, and they are not as liberal as your typical right of an adult outside of high school. And that's why they use a lesser standard of reasonable search as opposed to a probable cause, reasonable cause. But even under that lower standard, it was found to be unreasonable. And I think it shocked the conscience of a nation when we all read about it. But one of the interesting points, though, is that not all freedoms are absolute, and it depends upon circumstances, when, where, and who they apply to. Not that there is a lack of uniformity because of race or religion, but because of your connection with a public institution or a private institution. My emails, for example, can be seized and searched. And a private institution even has more rights to limit an employee's rights. At this point in time, however, I want to leave the remaining time open to you to ask questions of our panelists. And I would ask if you have a question to come on down if you don't, if you're uncomfortable, and speaking in the microphone so it can be caught on tape and on video. Yes.
My name is Michael Emmanuel. My question is that I do believe that the president does appoint the Supreme Court nominee, then the Supreme Court nominee is confirmed by the Senate. So do you really believe on ideological basis, do you really believe that the president can influence the decision of the nominee while making a critical decision?
The question was that the president obviously has some motive in picking the person. It could be a personal friend. But in the modern era, certainly in the last half century, it's been increasingly the political philosophy or ideology of the nominee, and whether that conforms to the president.